In this video we're going to look at unfair dismissal and how to go about suing for that. This is not legal advice. You should consult a solicitor or do your own research. This video will get you started. They'll show you where to look and what the words mean, and basically start putting the pieces together in your head so that you can go away and do much more effective research. So we're just covering the fundamentals here. So the very basic law is that when you're dismissing an employee, an employer must act reasonably, have a valid reason. For example, being a pregnant woman is not a fair reason to dismiss an employee in and of itself, and they must follow proper procedure. And you can challenge any of these three things. So the first step is you need to get a written statement, and you are entitled to this if you've worked more than 2 years or you've been dismissed while on maternity leave. And in this written statement, which you may already have got, if you don't, you must get it, they'll state this is why you were dismissed, and you can decide whether that's unfair or whether their explanation is in fact fabricated or untrue, and what the true reason is. So there's three different words that you have to understand what you're actually claiming. There's unfair dismissal, which is where you're dismissed for unfair reasons. There's constructive dismissal, which is where you weren't actually dismissed, but it became impossible to continue in your job. For example, you were the CEO of the company and you were demoted to the cleaner, and you resigned. They can't say, well, you weren't dismissed, you had a job as a cleaner, but you were the chief executive. And then lastly, there's wrongful dismissal, and people mix up unfair and wrongful. Wrongful dismissal is where your employment contract has been breached. For example, you could not be dismissed in that way or for that reason or whatever. Unfair is you've been dismissed for an unfair reason. Wrongful is you were dismissed in a way that breached your contract of employment. So get straight in your head which one you're claiming when you present your case and are putting together your case. So firstly, these are the fair grounds. If you're found that this is one of the reasons why you were dismissed and this is true, you're not going to win when suing for unfair dismissal. So fair grounds is gross misconduct. For example, if you punched another employee, smashed equipment, falsified financial documents if you were an accountant, those sort of things are perfectly fair to dismiss someone. Statutory restriction, that's where you simply can't do your job. For example, you're a truck driver who lost their license for drink driving, that's a fair reason to dismiss you. Impossibility is for some reason that it's just impossible to continue employing you. Redundancy is fairly self-explanatory. Illness, controversially, can be a fair grounds, though the employer is expected to support you and give you reasonable time to recover. And the kind of catch-all is a substantial reason. That's one that's not specifically covered, but is a very good reason for dismissing an employee. So constructive dismissal, if you're suing for this, it must be serious. The changes that they're forcing on you, for example, moving you from a store manager to the cleaner, which causes you to resign, which is effectively a dismissal, the changes must be completely unreasonable. For example, if they were taking away the free coffee and you're on £50,000 a year, that's not grounds for constructive dismissal. Harassment and bullying, if you can prove that, that's effectively making your job impossible, so you're in a sense being forced to resign. You're not getting paid is a perfectly valid reason, and unjustified demotion, which we've covered. It's not an exhaustive list, but that's generally the sort of things you're thinking about. Next step is decide whether you should actually sue. So you ought to think very critically about, was the reason unfair? And I know you want to find that the reason is unfair, but is it legally unfair? It's a bad idea to bring a suit for unfair dismissal where there's a chance that it really wasn't unfair. And the key question to ask is, would I have dismissed myself? If I was my own employer in a kind of sense, if you were your boss and you were employing yourself, would you say, right, this person just has to go? They're useless, they're lazy. So look critically at your work and say, actually, yes, I should have been dismissed. And if you go, no, actually I was very, very good and I can clearly demonstrate that I did my job very well, and you're being dismissed for an unfair reason, then perhaps you've got a case. And lastly, you have to ask, are you an employee? And this seems like a silly question, but you must be an employee of the company. If you're self-employed, if you're perhaps on 0 hours contract, you don't have the same protections as someone who is legally an employee. It's a very important distinction that you need to research. So the next step is an employment tribunal, which you must bring within 3 months. You should look up the tables for the basic award and then find the basis for calculating the compensation. So it's 2 parts of that award, and you can calculate what you expect and calibrate your expectations to that. A cheaper alternative to going to a full employment tribunal is the ACAS arbitration scheme, which is very well worth researching. The bad news is that median award in unfair dismissal cases, where there is actually an award, a lot of cases are never won. That's only about £4,000. So you have to be very careful. Often people run up bills in excess of £4,000, and that's both the employer and the employee. So you can be suing for unfair dismissal and spend £10,000 and get 4, and you don't get your costs. The employer might spend £5,000 try to defend a £4,000 claim, which is very irrational. So I advise you to try hard to settle. Your employer may admit fault or may come to some settlement that means they don't have to go through all the courts and hire all the solicitors. This is what you need to prove, and you want a damn good case. It's hard to win an unfair dismissal case, but it can be done. You have to prove that you were dismissed for an unfair reason. Ideally, this would be a reason written into legislation. You have to show that you're qualified and competent. If you show, yes, I'm fully qualified for this job and I did my job very well, and here's all the emails and here's all the performance appraisals and they're all wonderful, and they're saying, oh, you're rubbish. Well, why did they write such wonderful appraisals for you and then suddenly decide that you were always rubbish? You could show that they made no reasonable adjustments. If you were suing for discrimination, for example, if you worked at a multi-billion-pound bank and they said, oh no, we can't possibly afford to put a ramp in for your wheelchair. Well, that's clearly quite unfair. No consultation is often considered to be unfair. It shouldn't be a complete surprise to you that you were dismissed. So you want warnings, and you want some sort of right of appeal that falls into the procedure. An employer must follow the correct procedure. So even if you weren't dismissed for a fair reason, if the employer has not followed a proper procedure, you can sue for the fact that the procedure followed was unfair to you. And lastly, here's some pieces of law that you should have a look at. There's the Equality Act of 2010 and the Employment Rights Act of 1996. I would recommend that you read these. These are the kind of substantial basis of your case. So hopefully this has given you a lot to think about. It's pointing you in the right direction, and I wish you the best of luck. Thank you very much for watching.